between 2005 and 2014, remember the PMLA Act came up in 2002 for the first time, but as far as ED raids are concerned, between 2005 and 2014, there were 112, but between 2014 and 2022, there were 3,010. Shadan, given the low conviction rate, and it's an abysmal conviction rate, do you believe this is essentially a tool to pursue a political vendetta?
Yes, so we have seen in the last many days, almost all political parties have been targeted using ED by the central government. So I think it's quite obvious that there is a purpose, the law has been repurposed or weaponized in a certain way to deal with the opposition. Now, today's judgment, it comes in that particular overuse of the law. It comes in that context. And the fact, I'll just flag some of the aspects which were, there were a whole range of things which were challenged. Yeah. Obviously, in a program like this, we can't deal with every legal aspect. But some of the things which were challenged and which have, where the challenge has been rejected, was that at the stage of arrest in a normal FIR, under normal criminal procedure, you are given a copy of the FIR, you are aware of what the charges against you are.
Yep.
In ED cases, it's something called ECIR. And as per the law, there's no requirement to give you that. So effectively, you are being investigated. You may or may not be accused. You don't even know that. And you can even be arrested without knowing what the charges are. And that prima facie, it was argued, was unconstitutional. But that argument has been rejected. That's one. Then in certain aspects, there was a reverse burden of proof. That is, normally the burden of proof is on the prosecution to prove the case. But in this case, there was a reverse burden of proof after small aspects which have been proven by the prosecution. That again has been upheld by the court.
Right.
And there was a committal to trial that, you know, when you're committed to a trial, the person has to be physically present in court, the accused.
Yes.
There's a provision here which allows you to do in his absence. That again has been upheld. Then bail provisions in 2018, the Supreme Court, another bench, a two-judge bench, had set aside the second two conditions of bail as unconstitutional. The Parliament in April 2018 thereafter reintroduced more or less the same provisions with slight changes. Now that reintroduced provision has been upheld in the two strict conditions. That is, if prima facie the court is of the view that the person is guilty, after hearing the PP, bail can't be granted. So that is also a very, very strict provision. So that again has been upheld. So, you know, there is a whole range of mechanisms which go away from the normal law of IPC, CRPC, and all of those have been upheld. Okay. So, I mean, I don't think it's too difficult to imagine for any of us that given the context that, all that is happening in the country, this, of course, for purpose of criminal defense in all these cases.
You're weaponizing the law is what you're saying, right?
It's just going to make it very difficult.
All right.
To get
Let me get a response to that.